Okay, I think it's time to start. I would like to welcome you to this session organized by the European Federation of Data Protection Officers. And I want to take the opportunity to give you a short introduction of our federation. So if I can get the slides, please. Thank you. And there is somewhere, yeah. I'm Pierre-Yves Lastic. I'm the General Secretary of the European Federation of Data Protection Officers. In my former life, I was the Chief Privacy Officer of Sanofi, a large pharma company. We are now an organization of 17 national associations of data protection officers. Of course, we are first a European association, meaning we are not a European Union, but a European association. But we have also associated members, for example, in the Pacific, because France has also territories there. So GDPR applies also in Tahiti and New Caledonia, for example. So we have our sister association in the Pacific. And because our colleagues in Portugal works very closely with the Brazilian, who have also a very similar legislation now in Brazil, we have associated members outside of the of Europe, like Brazil, for example. Our goal is to create a network of national associations to exchange with each other. Of course, we have there are in Europe some very large associations in large countries like France and Germany and Spain, but you have also a lot of smaller countries which are very active. And if you want to have a voice, then you need to join forces with others. So we have in our association our colleagues from Slovakia and the Czech Republic, and now very recently also Scandinavian members have joined us. So this gives us the possibility to represent something like 5,000 DPOs from all over Europe. And this helps us to establish a continuous dialogue with at the political level to proactively monitor the legislation and to think about what will happen, and this is the topic of this session, what this new legislation brings in terms of our role as DPO and how this role will evolve. So I mentioned already this exchange of information and know-how, the increased visibility. We work also a lot on training, education, certification of DPO, and we organize a lot of events and conferences. In our main target for 23 was to increase our influence in Europe, and we are happy to welcome 3 Scandinavian associations to EFDPO. So we have now Norwegian, Danish, and Swedish members in the association. We are partner with the Privacy Symposium that was in April in Venice, and we are happy to be partnering now with CPDP and to be able to organize this session today. And we have our member organization, which in general organize side events about European issues at the national level. So we had events in the Czech Republic, in Portugal, in France, and so on. We have a number of working groups, and I'm leading the healthcare sector working group. I spent 30 years of my career in clinical research, so I have a particular interest in this area. And certainly the healthcare sector is one that contains a lot of privacy issues. And it's important to understand how technical standards can help us to improve privacy and personal data protection. That's why we also partner with technical organizations. We try to understand what EHDS, the European Health Data Space, will bring in the future and how to put it up in order to be compliant with GDPR. How do you work with anonymization, pseudonymization, and synthetic data, and of course, artificial intelligence in healthcare. So I don't want to say much more about that. I will now start by introducing my speakers. And today we were supposed to have also somebody from the European Commission who was not able to attend. She proposed a replacement who was also not able to attend. So at the end, we asked 20 people from the European Commission, but this week it's impossible to get anybody from there. So we will have Michael Will from the Bavarian Data Protection Authority, which will give us the point of view of the data protection authorities. And we have two members of the EFDPO, the representative of the Czech Association, František Nonnemann, and the representative from the Austrian Data Protection Association, Judith Leschanz. And I'm myself the representative of the French Union of DPOs. So we'll have a vision of what DPO and Data Protection Authority think about how this tsunami of regulations coming on us will change our job, change our life. So I would like first to ask Michael Will to give us his point of view on how the role of the DPA is today and how he sees this new legislation potentially changing this role. We have seen that CNIL will probably be in charge of artificial intelligence, but it's not said that in Germany it will be the same. So maybe, Michael.
Yes. First of all, thank you for having me here, for your invitation, for the possibility to speak to you. And secondly, am I allowed to ask our audience?
Of course.
Oh, that's fine, because you know who we are, but I don't know who you are. And we are celebrating the fifth anniversary of GDPR. So I'm wondering a little bit who is, being a DPO, satisfied with this 5 years and who is not. Can you give me, by raising your arms, a short indication? I will precise the question and ask you, is your life as DPO, has it got better in the last 5 years or has it become worse in an overall view? Okay, who decides that his life has become better?
Oh,
oh,
that's
you are celebrating today. You are a little bit depressed, and all the other ones said it became worse. Really? And just let me ask another question: who would decide to get DPO again today? Okay.
Oh, there are a few.
There are at least some. Happy to see that. So the challenge will be to convince the ones who won't get a DPO again that it might be useful to reflect on that. And so I come to your question. What is the role of DPOs in the perspective of a data protection authority? It's a difficult picture I would like to give you. I've heard a couple of weeks ago from a colleague from the Commission, we had him here, that we as data protection authorities are guardians of a fundamental right. I was a little bit hesitating whether I should join this picture, whether I should adapt this point of view. But thinking that we as data protection authorities are guardians of a fundamental right, what is your role? And I would like you to invite to be deputy guardians. Is it something you are okay, which is okay for you? Or would you say, oh, this is a little bit too much in terms of guardian of a fundamental right or in the role of a deputy? And now, when I look in your faces, I see you're hesitating a little bit, what I can completely understand. In terms of guardian of a fundamental right is a difficult role, and it might cost your nights and your family and other things. And on the other hand, being deputy towards an authority is not a proper role for someone who is working in the private sector, maybe. So here begins the difficulty to describe the picture of what is really a DPO. At the end, I give you a more abstract description. You are one of the core elements that the GDPR is working. For me, the DPO is the core element because we have a regulation with the perspective of self-regulating data processing. We have no improvements of data processing. We have Article 36, but this is, it didn't happen in my life so far. I don't know whether anyone else had experience with Article 36 procedure. And so data processing works at the moment someone decides to begin with it. And so the role of a DPO in at least major companies for major processors is the first one who asks questions. Is all the processing activity in line with GDPR requirements? Is there a risk for the company that anyone may ask for damage or any other sanctions, might raise a complaint? And who is maybe the first one who asks, do we have, for all those fundamental requirements of the GDPR, the suitable procedures for our company? Have we a procedure when it comes to a data breach? Have we a certain arrangement when it comes to right of access or something? All of that, what might happen when a company has decided to start processing of data, and we are in the digital age. So at the end, every company has already taken this decision. This is the role I see for the DPO. What means that I don't see you as someone who should solve all the problems, but you should have the courage, the tenacity, and sometimes the flexibility to point his fingers on the problems a company might have when they process personal data. When it comes to me as a data protection authority, I know in the GDPR there is written you are my first point of contact, and we often use it, but at the end it's also crystal clear that the controller is the one who is who will receive our letters when it comes to the decision about taking any measures and correcting anything. So you are at the end also someone who might see a bigger picture than we have. I know that our situation compared to your situation is not as comfortable. As a data protection authority, we are working ex officio, or most of the cases when a complaint is on our desk. You have a quite different situation. You are working every day on the current questions anyone has in the company, which might not be as precise, descriptive, who might be not as clear for you what will really happen. And often they, I suppose often people in your companies come to you and ask me, can we do that? And then it's a difficult situation for you because you shouldn't have to decide upon that, but you should make clear at an early stage as possible where are the risks. And this is why I'm happy that the DPO has created this instrument, this structure of DPOs to make the system work at the end. When it comes to the new law arising on the horizon, and they are supposedly on the door already, when it comes, for instance, to AI questions, I think for us both, for me as data protection authority as well as for you, the situation will again completely change and not get better. We will have a couple of additional questions, and we will have to get good explanations from our technical colleagues as well as from the business colleagues. What are their goals? What will they have to do? And we may have, this is the question I put in the room at the end, even a quite different perspective when it comes to sharing data. And we are responsible for the control of these sharing data laws. I'm asking myself, is the next goal we have to look at, is there everything done and in line with the law to share data properly? Is there a right to get data? Now we have a negative perspective. We try to protect data. And in the upcoming laws, we might have the task to care for, have we to share data? This is a complete paradigm change, and I'm happy to hear what my colleagues will tell on this upcoming future. Thank you so much.
Maybe one additional question on this aspect, because if I remember correctly, the federal commissioner for data protection in Germany is also in charge of freedom of information.
Yes.
Is it the case also in the Länder, in the different?
Yes,
it's
a structure in most of the Länders also, and when you put the finger on this freedom of information questions, you might be right that there is also a different perspective. When do we have to say there is a right to access to data? But in my feeling, the perspective is, are there any borders that do not allow us to share data? And so at least on the authority level, on the level of the companies, DPOs are so far, instead of rights of access, not used to take this different perspective. The data protection authorities or the authorities in charge for freedom of information often also ask whether authorities shouldn't share data, but it is not the dominant question for them.
Because the Data Governance Act is basically about sharing public information.
Yes.
Yeah. So that will be interesting. So for you, it's currently more the negative side, so
it's completely about protecting data,
giving access to.
Okay.
Good. Thank you, Michael. Thank you very much. And now let's move to the DPO representative. And ladies first, Judith, do you want to give us your perspective from Austria?
Thank you very much. And thank you for your thoughts, as well as from your expression about the law tsunami that will come to us. I think I will use this. Now, I want to talk about the role and the function of DPOs expanded to adopt the new acts. There are some new roles, and we even, finished with to see how we fill out the old roles. Coming to the new acts, I will talk especially about the artificial intelligence and the Data Act. I'm sorry, I cannot take all of them because we just have 1 hour, and I cannot take one of it. I have to say I feel a little bit neglected because you see the bunch of new acts, but I come originally from the telecom sector, and I'm missing one act. This is the E-Privacy Act. It should be there since 2018, and still they're popping some really good new acts, but I'm still waiting for the E-Privacy. Yeah, it's forgotten. I don't think that will be the first in line. So if I'm happy, it will be the last. Yeah. But I'm not quite sure if not other things will pop out there before. So if we want to talk about the future of the DPO, I would like also, as we have talked before, what about the last 5 years and about the past of the DPOs? Yeah? There has been some countries in the European Union where a DPO was required by law. Especially in Germany it was the case. In other countries the DPO was not a requirement, but it was, voluntary. Yeah? And it was seen in that way if it's not by law, and some companies did then the voluntary DPO because it's kind of reputation and it shows that you care for data and so on. But the DPO voluntary or for freely has completely other tasks than the required DPO, yeah, the mandatory DPO. Yeah. So the DPO in Austria was that one that implemented data protection, yeah, that one that was responsible to implement data protection in the company. And now the GDPR arises, and now we have a completely different situation. Now, I cannot implement it anymore. I do it still somehow, but on the other hand, I should control it. Yeah? I should control the controller, how to say. Yeah? And now it's how to say it. I think in the last 5 years, you have seen that the border goes a little bit to the side of the mandatory DPO. That means a little bit more to the controller. I think last day I have attended. I was listening to a panel. There was someone said on the panel, I'm a data manager, I'm not a DPO, I can make decision. Yeah? And so this was, I said, okay, yeah, as DPO, normally you're not there to make decisions, yeah, but obvious, you do it because you get asked all the questions and you have been asked, should we do this? Are we allowed to do this? And then you can say yes or no, but it's not my decision. Yeah, this is still, how to say, not an easy task to get through the organization. And then you have some decisions, especially it was from the Austrian Data Protection Authority. It was a scandal at one big company in Austria, and the authority wanted to know who made the decision that this kind of data is used in that way. So, of course, the CEO said it was not me, the legal said it was not me, the DPO, of course, said also it was not me. So nobody was taken. And then I think in the decision it was saying that, yeah, obviously the DPO is not, how to say, it was a little bit more correct, politically correct in the speech, but it was in that way, it's not smart enough or not good enough to take their tasks. Yeah? And so this is somehow, you don't want to do it. Yeah, but that means you cannot find a job anymore as DPO in that way. We decided to found the Privacy Officers, the association of the DPOs in 2000. The idea was from 2016 on, and exactly because of this issue, how we should implement data protection. On the other hand, how we see our role, yeah, and not, how to say, now we are somehow 400 members, yeah, so there's still room left to get more of it, yeah. But how to say, not to be felt alone to deal with this issue. This really a new idea how to do this, how to feel in this new role. I'm the spy of the regulatory body, or still I'm doing the implementation. And we did there a lot of position papers at that time. One was from us. It was 30 pages. What is the role and how should the role be situated in the company? There was one from the BVD, the German one. This was 300 pages. That was really good. So, but we had some, I think, minor positions from a law of attorney. He said only a law of attorney could be a DPO. Yeah, so there has been a lot of uncertainty in that time, and we thought, okay, the European Court of Justice will then give the rulings, and then we will say, okay, how should be the function and how should the role be works. That big problem at the beginning of the GDPR, it seems there's no problem at all. Yeah? Nobody talks about that anymore. We have some issues with the conflict of interests, yeah, that's still, but that's not what we expected. We thought that would be something completely new and we don't know how to work with it, but how we can see there are so few rulings or so few decisions about the position of the DPO and how he or she should act. So obviously it works. Yeah? It doesn't make our life easier. If you've seen in your questionnaire, it's not even better, but it sounds somehow, yeah, we have worked it. Now I want to talk a little bit as well as there are internal and external DPO, and of course there are pros and cons. And an external DPO, I think the pro is that he really has more knowledge to deal and liaise with the authorities, whereas the internal DPO is here and you know him and you can grab him any time you're here and ask him questions. Yeah. What challenges we face since 2018? I think some of you already mentioned the lack of resources. I mean, 2018 there come up. Everybody needs a lot of people, a lot of companies needs to have a DPO. Where do we get them? Yeah, we still have not an European certificate about it. We have some schoolings, we have some courses, we have some conferences. There are even some conferences we make you to a DPO in 3 days, yeah. So it would be very easy task, but it would be really help to have an overall certification, yeah. Then the DPO already has a wide spectrum of tasks. Yeah? It's not only supervising the GDPR, also the education, also the trainings, also the implementing. So the responsibilities has been expanded, and it will be with the new acts again. Yeah, to develop the new professional areas related to privacy, especially if we came to the AI Act, is the field of data protection and privacy rights is booming. Yeah, I have a chat yesterday at a cocktail with somebody quite younger than me, and said, and I told her about that I'm doing data privacy for 20 years, and she was completely surprised. And for 20 years ago, that was an issue. You must be a very rare flower in this issue. So there couldn't be much of a DPOs at that time. So, yeah, it's true. Now it's really booming. That makes, how to say, our life a little bit easier, because you don't have to explain somebody if you're a DPO is what they are doing all the day. Everybody knows about now data protection, but on the other hand, it increases the tasks you have to do, and there's a still high demand of DPOs. Then there are new professional areas developing. There are just two factors. There's automation of processes in production offices that requires a lot of data protection, as well software augmentation. Yeah, so even in this 5 years of the GDPR, if you see how cloud is arising, or how software is arising, and software as a service, and so on, so that increases a lot, and that in everything of that is data protection. So data protection is really a horizontal issue that covers or need to be covered by everybody. Of course, this new legislation and how to do the training of DI to be useful for the organization and so on. It has also considered privacy regulation as well. So if I may just a few words with the AI Act, there is some clarification needed where AI Act and personal data is known in the GDPR overlap. I mean, the GDPR, we know it's the law. It's not perfect. None of the law is perfect, but there has been something missed, and I think some of this new legislation cover or embedded the GDPR. Yeah? So, for instance, for me, this was a standalone solution. Was this? Portability rights, yeah. I know portability rights from the telecommunications sector, and for me it was always to have a competition law, yeah, and it's not the data protection law, yeah. And in the praxis, I've never ever seen one request for portability. Yeah? We have one that it said, okay, no, but especially they wanted to have Article 15, yeah. And now with this new act, it makes sense, this portability, and getting to this competition law where it belongs. And now with this new act, GDPR is embedded. I think that now works really together. You see how the direction will go. Yeah? But of course, the overlapping has to provide, especially AI, the obligations to providers of a high-risk AI system, Article 10. But on the other hand, you have also the Article 22 GDPR, the partially regulates obligation that arises from automated decisions, but AI Act adds requirements. So there are still gray zones, questions for the DPO roles. Then their alignment of key roles under AI Act and GDPR the GDPR, you have the controllers, you have the processors, you have the joint controllers. In the AI Act, you have the providers, you have the users, you have the importers, you have the distributors. Are they the same? How they work together? Yeah, so this is a strong connection between data and IA system. Then possible to...
Judith, we need to...
yes, just 1 second. There's a dual mandatory requirements for the high-risk systems in the GDPR and the AI Act, data governance, record keeping, relevance of data, and so on and so on. So I could talk a lot of it and not even finish. But sorry.
We can continue afterwards in the break, but I would like to give the opportunity to František to give us the Czech point of view from DPO.
Hello, good morning. Maybe I have not mandate to speak in the name of the Czech Republic, but maybe just some personal views and maybe more optimistic view to the bright future of the DPOs and organization itself facing the digital regulation tsunami. Why we are discussing this topic, I think it's important to highlight that as in the Czech Republic it was the same situation as in Austria. Before GDPR, we were not obliged to have data protection officers. But since 2018, we have had, I don't know, hundreds, thousands of real professionals who deal every day with data flows, data mapping, impact assessments, complaints handling. They are assessing or writing information documents. So right now we have a really big number of experienced people, experienced professionals from the, generally speaking, data governance point of view. And as Judith mentioned, all the new acts, not all of them, but big number of them, require and will impose some new obligation to do some, or to implement some governance around the data sharing, data processing, AI Act, Data Act, and so on. And my point of view, or my idea, if I may say, is that we should not only be scared of the future, but we should discuss how to take advantage of the expertise and experience we have, because we have some experience with GDPR, and we should reuse them, at least because lack of sources, both monetary and human resources. And I have just two short examples when we can reuse some expertise we have. One is from the AI Act. AI Act imposed the obligation for the importer, creator, user of the AI tool, or tool with some kinds of artificial intelligence in it, to implement some risk management around it. Me personally, I came from the financial sector. We are used to do some risk management, to assess risk, identify risk. But generally speaking, it's about, or we assess the risk as the risk for the organization itself. We assess the severity if the potential harm, or we assess the risk from the harm to the organization point of view. And for example, when I am discussing with my cybersecurity colleagues, they are usually tell that this IT system is not critical, the risk is not high, because it processes only data about 100 people. Okay, from the cybersecurity point of view, it might be true, but from the GDPR point of view, we are not assessing risk for the data control, but for the particular individual, for one and each data subject in our GDPR language. And it will be the same in the AI Act. So one thing, or one approach, or one experience I think we can reuse or take advantage of our expertise is this different risk management approach, not assessing the severity of risk from the, or for the organization, but for the individuals who will be, or who could be affected by the data processing or use of AI system. And the second brief example is from Data Act. Data Act is about data portability, but not only of personal data, but as well of non-personal data derived from Internet of Things, generally speaking. And similar to Judith, I have not much experience with data portability in practice, because in banking sector, if you want to change the bank, we have another, and your bank account, we have another instrument. But at least to assess what data are personal, what are not, what are the rights, how to make it transparent. Again, we have some experience from last 5 years, so we can reuse it as well in the Data Act application. So I'm not afraid of the future. I see several issues, but also several possibilities how to broaden the role of DPO and how to make the role of data protection officer or data protection compliance, data governance compliance, name it how we want, to make it more broad and more comprehensive.
Thank you, František. Something that comes to my mind when hearing your different point of views is when I was privacy officer with Sanofi, I had my role as a global privacy officer, but also as French privacy officer before GDPR. And I was discussing often with my German colleague. And my German colleague had basically, in France, we had to register our processes with the CNIL. And in Germany, you registered them with the data protection officers in the old way. And I remember very much when we start talking about GDPR implementation, my German colleague was very afraid that what he had been doing for 20 years was not valid anymore. He had seen himself as the extension of the Data Protection Authority, yes, an extension of the authority within the company. Whereas in France, we had more the point of view that you help the operational people to do their job within the law, of course, but you are not seen as an extension of you are seen as part of the company and not so much as an extension of the authorities. And I know that when suddenly he realized that his register would not be his own register, but should be maintained by the controller, that was the kind of cultural changes that he could not really manage. So how do you see this? Have you seen these changes in your experience, Michael, between how the DPOs you are working with, how they see themselves, and how this has changed?
It's, in my point of view, ongoing discussion, and every company, I have the impression, is thinking every 2 or 3 years about the right location and the right role for the data protection officer. Often said, frankly said, I see more problems with the colleagues who had a long time role under our old national law, because, as mentioned, they had to care for data protection. They were the ones in the company who had to decide and to do whatever necessary when it comes to processing of personal data. With the GDPR, this picture has faded. Of course, the data protection officer is not, as I propose you, a really deputy of the data protection authorities, but he is a controlling function. And this means that he has to leave his hands quiet when it comes to decision making. And this is something we all normally like. We like to take decisions. We like to be accountable for something and not be quiet and say, okay, it's your decision, do what you want. I told you about the risks, and you will see what will happen. So this is a situation normally active people don't like. And so this comes to another problem. For the company, it's not easy to find people for 2 roles. expertise in data protection is still not very common. It's not easy to get qualified people, especially when we talk about the upcoming years for your company. So the consequences that often companies decide to have a mixed role for the data protection officer, and that's up to him to decide whether he is in a certain situation the controller, and in another situation more or less the manager for data protection issues. And that's why one reason of many, we started with our joint enforcement activity to get a more precise picture whether this situation is only a situation typical for Germany or even familiar in other countries of Europe, and to start a discussion on a more precise picture of what DPOs should do, and another important aspect, what they should be qualified in. I'm not the one who says a data protection officer should always be a lawyer. And I don't say he should always be a technical expert. In my point of view, I would like people who are familiar with law, with technique, and with organization. And this is a question I don't have an answer so far. Where is the profession who is expert in organizing companies, organizing big structures, and making sure that they work as the accountability principle in GDPR expects? One more loyalistic word, just one basic information. When we look at the recent judgment of the court, we see a strong tendency that data protection is not more and not less than a compliance obligation. In the so-called Proximus decision, the ECJ used that wording in only one phrase, but he used it. He didn't disagree with the general attorney on this specific point. And so I need, besides law and IT, this kind of compliance expertise. What doesn't mean, strictly stressed, that DPOs should be the compliance officers. Not at all, please. Does it help you?
Yes, well, actually, I think that there are very few people who are able to, if any, who are able to cover all these roles.
No,
this
but
is why
they should
in general,
try to and be interested in it.
Yeah, you have, I think, in big companies, you will have a variety of people. You will have lawyers, technicians, organization specialists, project managers who would take the role. In smaller company, you would rely on external DPOs most of the time because you cannot have all the knowledge in-house. So, but Judith wanted to react to.
Yes, I want to say something. You're right, it's about the technical, about legal, and about organizational stuff you should know. Andrea Jelinek as well said, as a DPO, you need to be communicative, you need to have communicative skills and standing, courage, like you said it before, because you had a standing. And we do some fun in our associations that, okay, if a company that has something that knows the laws, that is a technical expert, that knows the company, is an organizational expert, that means a little bit you need economic as well, then you have super communication skills and courage, then I mean it's a little bit a pity just to be a DPO. Yeah, I mean that one would run for a CEO if you say it.
I like that. I had another question first to the authorities. We have seen in the first, after GDPR years, it has taken a long time for European data protection authorities to start coordinate themselves and working together. From my experience and discussion with my reference authority, the CNIL, that there was a lot of discussion. The EDPB has done a lot of work, but it has taken at least 2 years before you had the first practical how do you say, text for DPOs to apply. You don't see that the same way. So
not at all. I think we look at a different picture, but I admit and very honestly that not everything the EDPB or we as data protection authorities are producing, are texting, is the best you can apply directly in your day-to-day business. So this is very clear. But let's try to take my perspective. We have a new law. We are responsible to apply it equally in Europe. So it's of biggest importance, after all, in the beginning years, to get to common positions. And that takes time in every organization, even when you look on data protection authorities. So maybe we were a little bit slower in the beginning years, but I don't think we were as ineffective as you described.
No,
for instance, when
it's ineffective, it's, as you said, it takes time.
Yes.
Simply to organize yourself and understand each other.
It's not about organizing ourselves. We had a clear picture of what is necessary. The EDPB and its secretariat were working, but we had to a little bit also select the questions which were of utmost importance. And when you remember, after the first and second year of GDPR, what was next? It was Schrems 2 in July. And this was another kind of tsunami for the data protection world. So at least at that moment, I think we started producing and working on a really good level. And of course, not everything is one-to-one practically usable, but there are clear guidelines and common positions which makes the things easier for all of you which have to deal with cross-border questions. So right now, I look at another phase of working of the EDPB. Phase 1 was the beginning cooperation due to the 101 complaints. We started discussing about practical cases, about clear questions and decisions. And this continued. The second phase is that what we are looking at right now with the DPO CAF, and we had with the first CAF on the use of cloud sector in the public sector. This was not driven by complaints, but driven by our own assessment of importance. And this again gives you a lot of feedback on the role of DPOs. You mentioned the importance and the increasing market of cloud computing. This gives us various questions. Not everything is solved in this, instead of the situations that is day-to-day situation that everyone has to apply in line with GDPR. But some of the core questions are not yet decided, at least at the EDPB level. And the second, this says, even very much important question was the question of the role of DPOs.
I think František had a remark to make.
Thank you for the discussion and for your point of view. It maybe arise another, not problem, we don't have problem, another issue in the future regarding the new.
I like your approach.
I was just joking, but some issue regarding the new data regulation and the supervision itself, because each piece of legislation either establish or intends to give some current supervisory authority some new powers. Data Act, AI Act, DMA, DSA, e-privacy, who knows what it is. And what I'm a little bit afraid is that, for example, in the AI regulation or in the practice, there will be at the national level different regulators. A few months ago, we had discussion in the Czech Republic with our financial sector regulator, Czech National Bank, about AI, and they said, we don't know still who will be the general AI supervision authority in the Czech Republic, but we as the Czech National Bank, we want to regulate AI within financial sector. And I'm really afraid that one regulator will supervise and regulate and certificate and issue guidance for AI use in financial sector, different in telco, different in healthcare, and then we will have one one general regulator, supervisory authority in the Czech Republic, in Poland, in Slovakia, and then we will have hundreds of guidance and the decisions from all the Europe, and it will be really not easy to face this, let's say, potential supervision disharmony when you will introduce some new process, some new model, or within the group of undertakings where you have financial institution, some publisher, healthcare provider. So what I'm a bit afraid is this part, which is not clear as far as I know, and I am a little bit afraid that we will have such different approaches, and it will not help us to go digital in the general meaning.
Actually, it's a very good point. That was one of the things that struck me, was the same as you said, that each of the new states is bringing a new supervisory authority, and in federal states that means also that there might be one per region, so that we will have a lot of coordination efforts necessary. I remember personally working in clinical research. We had a clinical trial directive that became clinical trial regulation, and it took 2 years just to have a European position of the EDPB to solve the issue of what is the legal ground for a clinical trial. Which was in France, it was either public or legitimate interest. In Germany, it was consent, and then the British or the Dutch were in between. So this is the difficulty when you try to run a multinational clinical trial. Is this disharmony was very difficult in real life. So we fear that if I think of, let's say, in the field of medical research, if we're working on developing an artificial pancreas for diabetic people, that means that you have an insulin pump, which is a device, which uses a drug, meaning that you will follow also under the clinical trial regulation, the medical device regulation, 600 pages, the Artificial Intelligence Act, of course, because this is what will make the link between the sensors and the others. So at the end, you will have a number of regulation, and adding also all the regional and national ones. I don't know how long it would take simply to solve the authorization process for such a clinical trial. You would probably need 2 years to get the authorization and develop. So that's what I think is my fear. And how do you see this? How do you see this coordination problem or this disharmony? Are you optimistic?
At the end, yes.
but it's at the beginning.
At the beginning, I see and accept all your questions, but we should look at them more precisely. Is it real situations that we have an improvement process? In GDPR, there's none. In AI Act, I don't see it either. So, not in a strict sense. And so medical system might be a little bit different, but one of the next steps, provided that we have an improvement process, is to decide clearly who is responsible. And one of the answers the GDPR gave us was the one-stop shop principle. That there is, at the end, one authority responsible for one company, at least when it comes to data protection. And maybe this might be also the answer for the other acts, just to give the decision and the thing you might wish to challenge from one hand and not from different hands, and you are not sure about the interplay. I know, and that's why I'm a little bit afraid and not as optimistic as I should be, that this means a lot of work, lots of communication, lots of new structures. But we will have to face it. will not change, because we are talking about so many very different questions at the end. For example, when you talk about AI, GDPR is only a small puzzle piece. You have so many technical questions. You have ethical questions. You have questions with legal property and many other things. I don't see the authority who has all the capacities we need. Oh, yeah. So we will have to get the best ones we get and try to give them a structure that works at the end and gives us proper decisions. But it's because it would be a shame if we had a proper law but a bad authority for it.
Thank you. At that time, I would like to open up the floor for questions. And who makes the first step? You have a microphone in the middle of the room. Who would like to ask our speakers or to make a remark? Yes, can you tell us who you are, please?
Yeah. If the mic's working, mic's working. I'm Simon Ania. I'm the data protection officer at Uber, not just for Europe, but also for the UK and various other countries such as Uganda and so on, because it's expanding too. We haven't touched on that, but I won't do that now more. The question I would have is, in this constellation with GDPR, which has a specific role for authorities and DPOs, expanding into these other laws, I sometimes call it the D-suite, the key feature, I think, of both the DPAs and the DPOs is a level of independence and autonomy. And what I do not see with the other regulatory bodies pointed at in these new laws is independence. I don't see it. Maybe it exists, but it isn't there. And to an extent that there are DPO-type roles in some of these laws, they're also not independent. What is the panel's view on the tension that would give if a data protection authority or a DPO under these new laws has specific tasks but is not independent but could be instructed by those who take the decisions to look sideways or to rearrange priorities? So how would DPAs, how would DPOs have to cater for that? Because, of course, under GDPR, they would still be independent. So can you see the tension and how that would work out? And can we still correct it in the legislative process, if it is an issue?
It's a really interesting question. I think it's Michael.
Yes, I have a proposal for an answer, but let's discuss about it. I've asked myself the same question several times, and the only answer I found was a text from a general attorney at the ECJ touching the case Meta versus Bundeskartellamt, our competition authority. And there, the discussion was about the possibility of a competition law authority to decide on data protection issues. And so we come closer to your question. And the solution the general attorney suggested, it's not decided so far, is that there is a legitimate situation for other authorities to deal with data protection questions, but that the last word has to be spoken by the data protection authorities, what means that there has to be established, and we had this issue, a strong structure of cooperation, of information, of exchange of views, of doing joint investigations maybe also, and at the end there will be a prerogative for the data protection authority. What is based on its role in the Charter of Fundamental Rights, because only independent authorities have the power to decide upon free flow or protection of data. And this is a picture I have when it comes to the new acts. We will be always involved. And this is the thing I'm not happy about. We will be always the ones who deliver the decision when it comes to the aspect of personal data.
But the point I was trying to make is that, yes, but now we have the competition authority already taking on that case, will the DPA have to be instructed to stay put until they're finished, or will it go about in its own independence to be in parallel? So, yeah.
Okay. In parallel means in the moment there is a case at, for instance, the competition law authority, I have to jump in and begin not respecting whatever other tasks I have. Not the question.
What the question is, the competition authority is investigating.
Yes.
But the data protection authority, all its wisdom and independence, decides to also have a parallel investigation on the data processing aspects, irrespective of the fact that the cartel is already busy with the same case.
Okay. Then I would ask myself the question, and the company would ask me probably also, what is the additional outcome of your investigation as data protection authority? And regarding all the cases I have on my table, I would accept it, provided that I'm relying on the competition law authority that they will care for the same aspects I would have. And this is the meaning of this cooperation idea of the general attorney. We will also inform us and talk about the scope of the investigation, the major or minor points, and then make sure that at the end one investigation is enough to clear all the questions.
I'll stop here. I have lots of additional questions.
Yes, if you want to, we will come back next year and have another panel on it.
Okay, Jean-Pierre, if I may.
Yeah, of course.
React not to the DPA and its independence, but regarding the role of data protection officer, potentially broaden within the scope of the new regulation. For example, in the Data Act, in the DMA, I think the regulated entities are obliged to nominate some compliance function, and maybe it will be the same person. And that's true. They are not explicitly written that those compliance function should be such independent or such should have such strong independence as it is certain in GDPR. That's true. On the other hand, if you use the word compliance, you have some other standards, benchmark like ISO, for example, and if you use the word compliance, it in itself has some level of independence. So I am not afraid that this potential broadening of the roles of current DPOs will lead to lower their level of independence. If you are compliance officer responsible for something, you should act independently. You should have the direct reporting line to the board. You should have your own resources to do your business, and it's in the word compliance. So I'm not afraid of this aspect.
Just another word to be the independent role of the DPO inside. Of course, that makes you somehow a little bit suspicious.
I'm sorry, I just want to attend Jean-Pierre that we have last 5 minutes.
Okay.
Yeah, that makes me a little bit suspicious. So, because to be independent and the other guys, they are not in that way area working is normally the union group. Yeah, so of course, from the side of the management, sometimes it's a suspicion against towards DPO. Yeah, that makes the role, how to say, even a little bit more difficult. Yeah.
So, another question from the public. Wait, it looks like everybody. Oh, yes, there is one.
Many thanks. I am Alexander Strel from the University of Namur and the think tank there. I wanted to ask you, because you mentioned that you were coming from the financial industry, and the question is whether do you think that's where digital regulation is going? My impression is that, at least for the big tech, the inflation of law that we have now in Europe will make the big tech like a big bank, with a kind of deep and constant regulation where compliance is becoming very key. So do you see that tendency, and how then the DPO or another form of compliance officer, because I'm not sure that it should be the DPO in charge of, for instance, the DMA, which is more market regulation, but should we inspire by what we see in banking or not really?
It's not easy to answer. Thank you for your question, because if there's any sector, I would say, or if I should name one sector that is over-regulated, I would probably name the banking industry. So I don't think it's the ideal example. But on the other hand, there are some issues or some trends you mentioned, like big tech moving to financial sectors, and we as a banks are not afraid of Revolut and Nubank and N62, what you have in Germany, but we are afraid of Google Pay and Apple Pay. So maybe the whole digital regulation will have to somehow merge with the financial regulation, especially for some players. And we are going back to the supervision or supervisory communication, which is important. But I don't think that we really need such a huge and detailed guidance, supervision for all the new digital legislation, if I answer to your question. Thank you.
Okay, another question from the public? No, it looks like everybody is eager to go for lunch. Okay, at that time I would like to thank the speaker of this panel. Thank you for your attention, and I think there is another panel starting soon after this one. So thank you very much, everybody, and enjoy the rest of the conference.
Thank you.